You stopped paying rent, or you stopped paying rent, or you're about to, or you're just scared of what happens if you do. Here's what almost nobody explains to you. There is no button your landlord can press that removes you from your home the day rent is late. There is a legal process. It has steps, it has timelines, and knowing them can buy you real time, sometimes weeks, sometimes months. Let's walk through exactly what happens in order and what the law actually requires at each stage. Step 1. The notice. Before a landlord can file anything in court, they almost always have to give you written notice first. In most states, this is called a pay or quit notice, or a notice to quit for non-payment. It tells you the amount owed and gives you a set number of days, often somewhere between 3 and 14 days depending on the state, to pay in full or move out. About half the states base their landlord-tenant law on a model law called the Uniform Residential Landlord and Tenant Act, drafted in 1972. Under that framework, a 14-day written notice for non-payment is common. But this is genuinely state-specific. Some states allow notices as short as 3 days, so check your state's actual statute, not a national rule, because there isn't one. There's one major exception worth knowing, because almost nobody does. If you live in federally subsidized housing, or in a building with a federally backed mortgage, think FHA, VA, USDA, Fannie Mae, or Freddie Mac loans, Section 8, public housing, or low-income housing tax credit properties. There's a separate federal law that applies on top of state law. It's Section 4024 of the CARES Act, codified at 15 U.S.C. Section 9058. It requires a full 30 days written notice before you can even be required to vacate for non-payment of rent. Here's the part that makes this a good story. In February and March of 2026, HUD and the USDA both rolled back their own internal regulations that mirrored this rule. Some landlords, and even some agencies, treated that as the end of the 30-day requirement. It wasn't. HUD and USDA only repealed their own regulations. Congress never repealed the actual statute. Courts have continued to treat the CARES Act notice requirement as binding on covered properties, and tenants have successfully used a missing 30-day notice as a defense in eviction cases. If your building is federally backed or federally subsidized and you only got a few days' notice, that's worth raising. Step 2. Filing in court. If you don't pay and don't leave, the landlord's next move isn't showing up with a truck. It's filing a lawsuit. In most states, this is called an unlawful detainer action. Some states call it a summary process or simply an eviction case. But the function is the same everywhere. The landlord has to sue you in court. You then have to be formally served with a summons and complaint. Improper service, the wrong person served, no proof of service filed, notice just taped to the door where your state requires personal service, is an actual defense that can get a case dismissed and force the landlord to start over. Step 3. Your response. Once served, you typically have a short window, often 5 to 10 days depending on the state, to file a written answer with the court. Filing an answer is not you admitting you owe the money. It's what makes the case get heard by a judge instead of decided automatically against you. Step 4. The hearing. At the hearing, the landlord has to prove the notice was correct, proper, and properly served, and that the amount claimed is accurate. You get to respond, including raising defenses like improper notice, retaliation, or habitability problems the landlord never fixed. Many cases settle or get dismissed on a technicality at this stage. This is also where a missing CARES Act 30-day notice, if it applies to your building, gets raised. Step 5. Judgment and the writ of possession. If the landlord wins, the court doesn't hand them your keys. It issues a judgment for possession, and then a separate document called a writ of possession. That writ authorizes a sheriff or other law enforcement officer, not the landlord, not a property manager, to physically remove you if you still haven't left by the date on the writ. That distinction matters because it leads directly into the most important legal fact in this entire video. The landlord cannot skip these steps. Changing your locks, shutting off your water or electricity, removing your belongings, showing up and telling you you're out. All of that is what's legally called a self-help eviction, and it is illegal in every single state in the country, regardless of whether that state has adopted the Uniform Residential Landlord and Tenant Act or has its own separate statute. Only a court-issued writ enforced by law enforcement can lawfully remove you. If a landlord tries to force you out any other way, that's illegal, regardless of how much rent you owe. So here's the real timeline. Written notice first, 3 to 14 days in most cases, 30 days if you're in federally backed or subsidized housing. Then a lawsuit has to be filed and you have to be properly served. Then you get a real window to respond. Then a hearing where a judge, not the landlord, decides. And only after a judgment and a writ of possession can law enforcement remove you. None of this means you should ignore a notice or a lawsuit. Responding early, documenting everything in writing, and knowing your state's specific notice period is what actually protects you. But the version where you get thrown out overnight the moment rent is late. That's not how it works anywhere in the United States. This video is for educational purposes only and is not legal advice. Eviction notice periods, court procedures, and tenant defenses vary significantly by state. Always check your state's specific landlord-tenant statute or consult a licensed attorney for your situation. If this helped you, hit subscribe. Every week, we break down real legal situations in plain English. Drop a comment if you've ever gone through this. Your situation might become the next video. See you next week.